The broadcast is now starting. All attendees are in listen-only mode.
With Erica Fitzgerald. I'm Cheryl Frischman. I'm here with Erica Fitzgerald, who's one of the attorneys that works. Welcome to the webinar. Today we're going to be talking about Section 504, what is covered and what services are available. I'm Cheryl Frischman, and this is number 5 in our very special webinar series. I'm here with Erica Fitzgerald. She's an attorney here at Littman Krooks, and she is our resident expert in 504. So say hi to everybody.
Hello, everyone. Welcome to the webinar.
And today we're going to talk about 504, and I'm so happy that we have the opportunity to do this because the 504 is one of the most misunderstood areas of special education law. So before we talk specifically about Section 504 and what it means, and I can't move the slides, so we're having a little bit of technical difficulties, I will talk about some of the laws that are applicable to students with disabilities. Section 504 is just one of them. Section 504 is just one of the laws applicable to students with disabilities. We have the IDEA, which we've talked about in the last 4 webinars. The ADA, No Child Left Behind, and DASA. Those are some of the laws that Erica and I deal with. These are the laws that we deal with most of the time when we're talking about students that are in school. No Child Left Behind and DASA they apply to all students, whether or not they have a disability. Section 504, the IDEA, and the ADA, those are only applicable to students with disability. Why do we have these laws in schools? Well, it allows students with disabilities to have the same rights or access to the program as other students. It gives everybody equal opportunity, not just equal treatment. It gives a legal remedy for those experiencing any sort of discrimination. That's why we have a practice in that area. Lawyers wouldn't have a job if there wasn't a law to be broken. Private entities, and we'll talk a little bit about that, may be exempt. Most of the disability laws, at least especially Section 504, they typically only pertain to schools that, or places that receive some sort of federal funding, okay? So when you're talking about a parochial school or a yeshiva or a private school, there's questionable what do they have to provide, or can they discriminate based on disability? And either way, whether we're looking at 504 or we're looking at the IDEA, the disabilities in laws in schools, they ensure that students get FAPE, a free and appropriate public education. They mean different things depending on whether you're dealing with the IDEA or 504, but the basic thing you need to know is that they have to provide a free and appropriate public education. So if you have heard our previous webinars, you know that we have talked about the IDEA and Part 200. And I'm just going to very quickly talk about this just for people that are tuning in for the first time. And please know that our webinars are all available on our website, www.specialneedsnewyork.com. So if you want to learn more about the IDEA in particular and what that means, you can go back and replay those webinars. So the IDEA and Part 200, these are special education statutes. The IDEA, the Individuals with Disabilities Education Act, is our federal special education law, the law of the land, and Part 200 is New York State's special education regulations, and New York can't take anything away that the federal law gives us, but can give us more. And for any more detail about the IDEA and the law in general, you can listen to the webinar replay. So in order to be eligible for the IDEA or to get special education services, it's actually a two-tier test. And sometimes this is where there's a lot of confusion because people say, hey, you know, my doctor diagnosed my daughter with ADHD and I should be getting special ed. And, well, maybe. So we have to look at letter A first and say, well, does the child have a disability? Yes. Okay, the child has ADHD. That ADHD may fall into other health impairments, which we talked about, the different classifications. But you can't just have that disability. You need to also meet B to get special education services, which means by reason of that disability, the child needs special education and related services. So what does that mean? That means that the child needs more than just accommodations. That means if my daughter, who is diagnosed with ADHD, can take the same test as everyone else, but needs to do it in double time, needs frequent breaks, has the same homework as everyone else, but maybe it's broken down into discrete parts. Maybe she gets preferential seating, but takes the same classes. That's not special ed. That's accommodations. My daughter would not be eligible for an IEP, which we've talked about a lot. She may be eligible for a 504, and that's where we get a lot of confusion because people think that, hey, my kid has a disability and they need all these accommodations and extra time. Okay, where's my IEP? Well, that you need somehow for the curriculum to have to be modified in some way for that child to be able to learn in order for the child to get the IEP. So that's very, very important to understand, and that's why we have Section 504. Section 504 is not a special education statute. This is a civil rights law. This protects you from discrimination. So, for instance, if my child were in a wheelchair and needed to go to school, they would have to make sure there was a ramp. If my child was in a wheelchair and needed, to get into a class, the doorways have to be a certain distance so the child can wheel themselves in. They're not changing any of the curricular aspects to the class, but it's almost like they're doing engineering, to make sure that the child has access. So you've got to think about it that way. So if I have a child with ADD, what is their wheelchair ramp? Maybe sitting in the front of the class, maybe extra time on tests. So it's different than the IDEA because all that it does, 504, is it protects students from discrimination. It requires schools to treat a child with a disability the same way and also give them access, okay? So like I said, in terms of what the school district has to provide, they have to provide a free and appropriate education. And we have talked about, and the case law has talked about ad nauseum, what is, a free and appropriate education. And you always hear about, if you've heard my other webinars, I talk about what is appropriate, and what does that mean. But also, we get an individualized education program, a contract with the district that they're going to provide certain things for my child to be able to learn. That's free and appropriate public education. That's a big deal. That piece of paper, it's not a literal contract, but we consider it a contract because what we're getting is certain resources have to be devoted to that child and for that child to reach their goals. That's very different than what a child that may be eligible under 504 gets in terms of what a free and appropriate public education. All that it is for 504 is education comparable to the education provided to non-disabled students, period. So let's talk a little bit about the differences between what an accommodation would look like versus what a modification would look like. You know, an accommodation provides equal access. So, like I said, the wheelchair ramp, sitting in the front of the class. It gives that child access to learning. They can't learn without that access. Provides students equal opportunity to present their knowledge. So if a child is taking a test, it may give that child extra time to be able to show what they know because of their disability. And we're not just talking, you know, ADHD or a learning disability. We're also talking about health disabilities as well that may have accommodations. You know, something that Erica knows a lot about is diabetes. And a student with diabetes may not have any you know, educational or learning disability or anything wrong with their brain or anything like that, but they need extra time to check their sugar. They may need to have more excused absences than other students normally have. They may need things sent to them electronically because they had to miss school, because that physical disability is having an impact on their learning, just like the child with a learning disability would have an impact. And so you need to think of it that way. And you need to, an accommodation can also, there's no list. I always get the, you know, the people that say to me, give me a list. You know, if your kid needs accommodations, we can, there's not a fill in the blank like an IEP Direct, which we all know about. You know, we don't have a list of accommodations. It's very tailored to that kid's or that student's needs. But the biggie is it does not substantially change instructional level or content. So if a child gets in to an honors or AP class, okay, so let's say the cutoff is a score of 90. So a child with a disability and that has a 504 plan, let's say they get an 89. Do they get in to that honors class? No. You can't, you have to get in. Like, you've got to pass the test. Can someone put you on the football team if you can't play football? I mean, no. I mean, you've got to make the football team. But once you make it, once you get into that honors class, so you got a 95 on the test, does that classroom teacher, even though it's a general ed class, have to give the students their accommodations? Of course. Do you take away their wheelchair? Do you take away their ability to test their sugar when they go into their honors class? Absolutely not. With that child with ADHD, with a learning disability, they get their front row seat. If that's what they need, they get their extra time. But they have to, they get access, but they have to still make it. You don't get any preferential treatment. So modifications, on the other hand, are going to change what a child is expected to learn. So you can't have a child with an IEP, possibly, okay, if the IEP has an academic tone to it. There are people that have IEPs that are maybe more for psycho-emotional or behavioral, that may be different. But in general, you can't ask an honors teacher to cut an assignment in half. Okay, you can get more time maybe, but you're going to take that same test. Okay, it may take you longer, but you're going to be expected to learn that same information. So a modification would be, look, we've got to modify the homework here for a child. We have to change the instructional levels or benchmark. Number of key concepts mastered within the benchmark. And it changes in some way the content or curriculum. And so it's very different what you get under a 504 plan and what you would get under an IEP. To make things even more complicated, do you automatically even get a 504 plan? Well, what if I have ADHD and I'm taking medicine and I'm doing fine? Like, I'm just doing fine. Like, I don't need preferential seating. Like, I don't need the extra time on tests. I've shown over and over again I can get hundreds and I don't need it. And I'm organized somehow. I figured it out. Does that mean that I'm not protected under 504? Absolutely not. Okay? They can't discriminate against me. They can't say to me, oh, you know, she is so messy and we can't have her part of our class. We don't want her in this art class because she's so messy. But I don't need a 504 plan, but I can be protected under 504, which means that if the school knows I have a disability, because I'm messy and I let them know, and they discriminate against me, I can still sue. But that doesn't necessarily mean you get a plan, okay? Because if you can be disabled and not need a plan. A lot of people before a lot of these disabilities were even recognized went through school and figured out ways to cope. And if I can get straight A's and I have taken medicine, I can take medicine on my own somehow, that I know to take it on my own. I take it before I go to school in the morning. I've completely put in place an organizational system that works for me. I now can take my tests. I took a speed reading class and I can take my tests on time. They don't have to give you a plan just because you have a disability, but you're still protected. So you need to understand that everybody, by virtue of having a disability, is protected. You just don't necessarily have a plan. So this circle in the middle, the IDEA circle, should actually be really, really tiny. But as I prepare more and more PowerPoints, they get more and more spread out, the circles. I just wanted to give you some sort of a visual because it really is this teeny tiny circle in the middle of students that are covered under the IDEA. The rest of the disability world in school is really in that 504 bubble. Now, you're automatically covered under 504 if you have an IEP, so you don't need a separate plan if you have an IEP already that's already incorporated. You're already considered protected under 504 if you have, so you don't need a separate plan, but it's not the other way around. So that's kind of what that visual was supposed to show you, but that little blue circle is really tiny, okay, compared to 504. So the steps, we have similar steps. So that's why it says in 504 and IEP there's similar steps. It's just sometimes those steps look very different, and they do with a 504 and the IEP process. So we're going to go through those steps. So in terms of referral, so in terms of the IDEA, like we've discussed, any student suspected of having a disability, a parent, a school, a teacher, anybody can refer a child to the CSE committee. So if mom suspects that there's a disability and school may not suspect that there's a disability, they have to go through the whole process. There's a referral made, and they have to go through the process. Interestingly, in 504, yeah, the parent or school could make the referral and should. Now, just like an IDEA, the school districts have an obligation to find their disabled students, even if the parents don't bring it to their attention, and accommodate them, okay? But let's say I refer my daughter over to the 504 committee, and they're like, no way. She's fine. She doesn't need extra time. She's getting hundreds. I don't see any of this stuff. They don't have to go through the 504 process. So you can make the referral, but the difference between 504 and the IDEA is the school district must also have reason to believe that the child is in need of services, okay? Now, take it as you want, but, sometimes parents knowing this may go through the IDEA process. Again, I'm not telling you to do that because it does use a lot of school district expenses, but maybe when discussing the referral with the school district, say, hey, I can just take this through CSE, can we just do it? And they would be much more amenable to agreeing with you rather than using, having to go through the entire CSE office to get certain accommodations. So, what you know about this firm, what you know about me is I'm all about building that relationship, collaborating. If the school district says no and you immediately go to the CSE office, that's just already setting up this parent just went around and didn't. The time to fight is when you're fighting in the meeting, maybe. Save your battles, pick your battles, okay? So just some things to consider because I feel like, especially where we live in Westchester and where we do a lot of our practice, it seems like everyone has a 504, okay? When I teach this to teachers, and when I'm called in on to do staff development on 504, this number freaks everybody out because only 1 to 2% of the student population in any given school is deemed 504 eligible. That's what it looks like across the country. That's the statistic, okay? Again, you know, that may not be what it looks like in a lot of our districts. Learning disabilities are not always due to a physical or mental impairment. You know, again, in a high-achieving district, there's some parents that believe that their child is not a C student, but maybe their aptitude is they're a C student. Or let's say that they're really, really smart, but they're just obnoxious. No kid's obnoxious, but I mean they have a bad attitude, you know, they're obnoxious, you know, they're missing classes, they're, you know, just don't, they're cutting classes, you know, that doesn't equal 504. Now, do we want to maybe look at 504, you know, or see if there's a disability causing that? But sometimes you can have a bad attitude or a low aptitude, and that doesn't necessarily mean that you get 504. It's not a statute to get everyone A's and everyone good scores on the SATs, okay? It's not, again, for at-risk students. Like, we do a determination, of course, but if, let's say, parents are going through a divorce or, you know, the child lost a sibling, God forbid, you know, or something terrible happened, is that a 504 kind of analysis? I don't think so, you know. I mean, we have to just get the counselors in. Now, if resulting from that the child becomes depressed and has to go see a therapist and is all, you know, can't really rebound in a reasonable amount of time, and this has happened or has post-traumatic stress or something, then we may be doing a 504 analysis, but they wouldn't be eligible at that time. And this is huge. You know, the standard is we're comparing a student to that average student. That's the C student, okay? We do not have 504 nowhere says that we have to get a child to work up to their potential. And how many times have we had that student, or even, you know, my own child, who is brilliant and it is her disorganization that's getting in her way? So do we have to put in 100% accommodation so she can reach her potential? No. We just have to get her a ramp so she can get in there like everyone else, right? So it's the average student. So now she can show what she knows, but we don't have to, let's say she shows what she knows and that's C, and it's okay, C. We don't have to make her an A student if that's not her aptitude. So, again, you know, I went to the last thing to consider. Standard is not whether a student is reaching his or her own potential or parental expectations. But we do want to look at it or consider it when we do have these kids that are being, you know, expelled or suspended. We always do that analysis. You know, the kids suspended, should we look at whether there was a disability that we didn't look at before, and maybe that was the reason why they were suspended. At-risk behavior. You know, yeah, like when a kid is addicted to drugs at the age of 13, yeah, maybe there's something underlying going on there. So let's look at it. If we're thinking of holding a kid back, I would always look at it. Not saying you're going to get your 504. You know, if a disability is suspected, if the school thinks that, you know, there's something's going on, even if the parent doesn't suspect it. A chronic health condition, diabetes, you know, any sort of health condition that, you know, chronic fatigue syndrome, a whole host of things that you can have that may cause you, you know, the physical disability, like returns after a serious illness or injury. Student was, or of course, if a student is referred to the IDEA or to the CSE committee and isn't qualified, the CSE committee may say, you know, this is more of a 504 thing, so we're disqualifying you because you don't meet that number 2, you know, in that 2-tier test. But we do recognize that there is some impediment to your learning. It just doesn't rise to the level of an IEP that student would be referred to at 504. You know, not necessary, but it's always helpful. You know, we're talking about a disability here, so you really should have a doctor. I mean, it's not necessary, but it's really important that a doctor, you know, says, you know, this child has a disability. You know, evaluations need to be done at no cost to the student. That may look very different in the 504 arena. You know, a lot of times students come in with a prescription from a doctor or something, and the teachers all kind of get together and they're like, you know, we don't necessarily need formal evaluations, but if the district is recommending them, they can say, you go get a neuropsych and come back to us, okay? If they're in the process, they have to pay for the evaluation. And again, the school district is not doing any favor in evaluating or providing a child with a disability appropriate services. The school districts are required under the law to do so regardless of the cost. So what is the, who is on the team? Unlike the IDA, there's really no requirement that the parent be part of the team, but that's kind of silly, you know, but it, you know, I tell the school districts this, of course, it's best practice that you have your parents involved. So, but what it says is it's not like the IDA where they give you specific people that aren't there or you don't have a legal meeting. You know, so if you don't have a school psychologist there, let's say, and it's an initial CSE in New York, or you haven't given the parent an option for a parent member to come at an initial meeting. If there's not a special ed teacher, you know, we have in the IDA and in Part 200 all sorts of people that must be there, okay? Not so with 504. All it says is placement decisions are to be made by a group of people who are knowledgeable about the child, the meaning of the evaluation data, placement options, least restrictive environment, and comparable facilities. So if the child is having, you know, difficulties, they may bring in a lot of different people. Like the gym teacher could be involved in a 504 and often is. A music teacher can be involved in a 504 and often is. An art teacher. If you know that a child is going to have difficulty in gym because of this, you know, the gym teacher should be involved. You know, so it's kind of like we bring in the people that would have something to say that's meaningful. There's no maximum. And we're not going through the director of special education typically, usually not. These are building level programs. Remember, this is access. So what you'll usually have in a school district is a 504 chair, you know, and that's usually the assistant principal or a psychologist in the school, like someone that understands the physical plans of the school and is aware of what can and cannot be provided for that student. But sometimes people assume that, you know, the Department of Pupil Personnel knows what's going on in the elementary school, not for 504. Okay, 504 is very school specific. The principal can be the 504 chair, and in many teeny schools is. Okay, so the process of going through eligibility. What do we have to look at? We have to first look at whether the child has a physical or mental impairment. Does that physical or mental impairment pose a substantial limitation on a major life activity? Okay, and if so, yes, we need to develop a plan. Okay, and we're going to go through that. What is a physical or mental impairment? It's almost anything. Okay, and it's even if the school, if people, it so covers almost everything to the point that if you're even presumed to have a disability and you don't, you're protected. For example, let's say I am a student in school and my parents both have AIDS, okay? And everyone in the school, no one comes near me. I don't have AIDS. But everyone comes near me, they won't come near me because I have AIDS. I'm protected under 504 because everyone thinks I'm disabled, okay? Does that necessarily mean I get a plan? No, but that's how open it is. Not only, so a school can be held liable for discriminating against me if the teacher doesn't want me in their class because they're scared that I may give them AIDS, which is not a reasonable thing to, you know, we know how it's transmitted. But so if that kid, you know, in school and someone's saying, that kid has Ebola, you know, which is the big thing now, you know, and nobody wants to go near the kid and the teachers aren't letting him in the class and no one's touching the kid and not helping him in art. I don't know, that to me, even if the child doesn't have Ebola, it would be covered under 504. But it doesn't really give us any you know, it says, it pretty much, it gives you a couple of examples, but it's anything, all right, pretty much. There are some exclusions, okay? So they do exclude sexual behavior disorders such as exhibitionism and voyeurism. These are mentioned in the law. Also excluded are compulsive gambling, kleptomania, pyromania, homosexuality, bisexuality, transvestism, transsexualism, gender identity disorders, environmental, cultural, and economic disadvantage alone, prison record, age, and child not working upward to his or her potential. Those are specifically in the law. And this is always the one that kind of gets me. Psychoactive substance use disorders resulting from current illegal drug use are not included. So if I'm a student that is addicted to cocaine and gets thrown out of school, you know, and this is the reason this is specifically excluded, and they find cocaine in my locker, or the big one now up here is heroin. They find it, okay? And mom wants it and says, look, you know, they have this addiction, like it's a disease. If they're currently, and by doing that, she wants to get the expulsion or the suspension lifted. No can do, okay? Currently using, you need to kind of go deal with it, and then you can come back and maybe a doctor can write, look, this is a child that has alcoholism, this is a child, then you can get your 504, but not while you're currently using. Because the reason that's in there, and I don't know the legislative history, but I'm thinking that school districts were like, well, we can't enforce every kid that we find marijuana in their locker is going to say they have and have a drug addiction, if you're currently using, that means if they find it in your locker or you're on it at school, you can be suspended. If after you get treatment, that doesn't mean it goes away. There is a recognition that these are, alcoholism is a disease, drug addiction is a disease. Again, a doctor's note on a prescription pad may not be enough. It sometimes is. But again, that the team is actually making that determination. It's not your doctor. So you just have to think about that. Like a lot of times, for instance, I'm sure Erica, when your child, they're not going to say, hey, we got to evaluate your son, right? And say, and check him out ourselves to make sure we know he has diabetes. Like in that case, they're going to kind of take the parent's word for it, and they're not going to do evaluations. But in those kind of disabilities that don't have any have a medical twinge to it, or if it's an ADHD or something psychiatric, they may require and may need some more. Some more information, okay, but to determine that you actually have that physical or mental activity. Okay, so what does substantially limit mean? So this is also important because remember what I said before, I can have a disease, like I can have ADHD and I could be okay, okay? So in order for me to be qualified for a 504 plan, that disability has to substantially limit. Okay, so we're not talking like a little bit limit, okay? We're talking, the word's pretty clear, this is not inappropriate. This is substantially, like the kid cannot learn unless, okay, you give him this access, okay? But of course the regulations fail to provide definition, but substantial is pretty, it's pretty heavy-duty word. But there have been litigation on this, and it does say that some of the case law has said, and it's now pretty established, that it means unable to perform or unable to perform. That means at all. Like you cannot perform. Like you can't get into the school without the, the ramp. I mean, cannot do it, okay? Or significantly restricted in performing a major life activity as compared to the average student. Very important, okay? It's got to be pervasive across every environment. You can have a kid that needs extra time in math. And now we have Common Core folks, right? So my kids are being tested in gym. So you need that extra time in gym too for those tests. You need extra time in English. You need extra time in Spanish. You need extra time in everything. It's non-selective and pervasive. Okay. Otherwise, it's not a disability, right? I mean, if you can do it in one class, if you don't need your wheelchair to get into one class, but you do in another, you know, you can't make that argument. And it significantly impairs access. Okay, so substantially, significantly. This is not a small little hoop, okay, to jump through. So again, there's a lot of major life activities out there, okay? The one that we always deal with typically is learning, okay? So does the ADHD have an impact on learning, okay? Does the diabetes have an impact on learning? So Erica, do you want to talk a little bit how diabetes, like to give an example of how diabetes could impact the learning of a student?
Absolutely. You know, with diabetes, everything is, you focus your life on controlling your blood sugar, and it swings up and down. When you're high, you're very hyper, or many times kids can tend to be very hyper. When you're low, you actually are unable to pay attention. You become very confused, not to mention the fact that it's life-threatening. Both situations are. So there are, you can never guess when you need to leave the room to deal with your sugar. Once you're out of the room, you're no longer receiving instruction. And it happens all different times of the day. There's really no set way. There's no way to come up with a specific plan, say I'll just deal with this at lunch or before class. In the middle of a test, you may have to stop. In the middle of a test, you may be low, and that means that you need 15 to 20 minutes, even after you've treated, to have your blood sugar rise to a level where you can, once again, be able to think enough to perform.
Right.
So, you know, even children who perform very well, it's a life-threatening situation which needs to be dealt with immediately. It's not something that can ever just
Right.
put
So
off.
it's not just that a child with diabetes could have the perfect aptitude and be a student that could get, you know, straight A's, but that doesn't mean that that diabetes isn't going to impact learning, okay, in some way if you don't accommodate them. Now, schools do deal with other major life activities, okay? For instance, if you have a wheelchair, okay, you can't walk. That's a major life activity. So they engineer, you know, they give you the ramp. It's not learning in that situation. That would be on the 504 plan, okay? Learning is only on the 504 plan when the disability is affecting the learning itself, okay? Important. Like if a kid can't stand or a kid can't sit or a kid can't reach, you know, there may be specific things that have to be done, but learning in some way doesn't have to be modified, okay? The building may have to be modified in some way. Allergies, big deal, okay? You know, if you have allergies, you know, maybe you're allergic to something that they're using in the gymnasium. Okay, that doesn't mean that, you know, you need extra time in a test. Okay, so, you know, that, when we're looking at extra time on tests and when we're looking at preferential seating and the type of accommodations that we're looking at typically in this office, and we usually get questions about, is learning. Okay, but that's really just one of many. Okay, so what's a mitigating measure? So a mitigating measure means, okay, so I have ADHD and now I take it, and I don't have ADHD. Now, you always have ADHD, but I don't have the symptoms. Does that mean that I don't have ADHD? No. I have ADHD. I'm still protected under 504. I may not get a plan, okay, but I'm still protected. So they can't just say to you, we're not going to have a 504 meeting because the kid's on medication. No, they can't force you to take medication either. The other, yeah, but what a mitigating, so those are typically mitigating measures, okay? So, for instance, if a child with diabetes can test their own sugar, can do all of that on their own, does that mean that they don't ever miss class, and they don't, does that mean that they're not a child with a disability? No, okay? They're just, they know how to deal with it. Maybe they need an inhaler or they need medication. Then they can deal with it. The big exception here, though, is like glasses and eye contact. So you can imagine, like, if I can't see and I put glasses on, I'm not protected under 504. Okay, so what is a 504 plan? It does not have to be written. Okay, that's why people want that IEP, okay, because it's like kind of like a loosey-goosey. It says, hey, the child has diabetes, this affects learning, these are the accommodations that we need, okay? Again, simple, easy, and enables teachers to implement. No goals, nothing. but it should list out specifically the accommodations. Again, accommodations do not change the content or material, at all, or how the student gains access, anything. It's just like like I say in the slide, which I think is a great word, environmental engineering. Okay, so also those accommodations are reasonable. Okay, there's no funding. If your child needs an aid to read a test to them, they're not getting any funding. Now, for kids that fall into the IEP, an IEP, there's funding that comes into those schools. So this is almost like one of those, we talk about all the time, unfunded mandates. 504 is one of them, okay? You cannot, there's no funding. Because of that, courts have found that accommodations must be reasonable. The school's obligations under 504 are not limitless, okay? So I just want to give you an example of the case I had, actually, where a child was allergic, to everything in the school. I can't even, we had to redo the fields, and we had to, all the cleaning solutions had to be different. And the school district tried, and finally they're like, look, it's gotten to a point where it's just, we can't do this, we're going to educate you at home. And the parent was like, no. And they're like, yes. And yes, you don't have to completely redo the school and rebuild it because the child's allergic to everything. So there is that, the courts have said there's, 504 is responsive to two powerful but countervailing considerations: the need to give effect to the statutory obligations and the desire to keep Section 504 within manageable bounds. So they don't have to give you a high-tech device. They have to give you a device, maybe, okay? It doesn't have to be the best. It doesn't have to be expensive. It just has to be reasonable, okay? They can't, for instance, if you, and also they're going to expect that you pay just like everybody else for athletic, locker fees, library charges, all can be collected. It's just, the accommodations are reasonable, and we're going to talk next about some of the common accommodations, and again, these are just some. I've come up with so many cool ones with my clients, with my kids, that work for them. But I thought the best way to do this, and we'll run through this quickly, is to just give you, a student with ADHD. So we found that they have a disability. This is a child that we went through the analysis, that this child acts up in the classroom, he's easily distracted, and it's impacting his learning, and he has a disability. Okay, so what do we do? Okay, here's an example. Classroom, front and center, near the teacher, away from doors or windows. Sit next to a good role model. Increase distance between desks if possible. For the younger student, mark an area of tape around the desk where a student can move more freely. Not from any law. This is just, I'm kind of taking this off the top of my head because this is what I would think about a student like this needs. Here is the student again who has ADHD. Same student. This is another problem they have. Maybe they have incomplete assignments, so they're unable to complete their work within a given time and has difficulty following instructions. Give them extra time. Break long assignments into segments. Shorten assignments. Pair written instructions with oral instructions. Set a timer for 10-minute intervals and have the student show their work to the teacher. Again, don't go taking notes. This is just an example because every student is different. The student who gets distracted, same ADHD kid, okay? They fall behind. It's impacting their learning, okay? Make careless mistakes. Provide peer assistance in note-taking unless students help to present the lesson. Have a special cue. I love this one, where the teacher kind of taps on the desk or says a word and then immediately gets the kid to refocus. Schedule 5-minute period for students to check over their work, maybe extra time between classes or to get their stuff together. Student who interrupts, same ADHD student. Maybe we're going to ignore the inappropriate behavior because we always say, if you reinforce bad behavior, it's still reinforcing that behavior. And create immediacy of rewards. Good job immediately when they're acting good, okay? So, now we're going to, the student is terrible during the entire class, but now they're quiet. Oh, what a great job listening, oh my God, great. great, you know, you're going to get an A+ today. You know, acknowledge correct answers only when a hand is raised. Send daily, weekly progress reports. Set up behavior contract with students, all just from the top of my head, okay? And again, student loses focus. So, I mean, I don't need to run through all these, and if you, for some reason, want to hear this again, you can. You will be able to replay it. You'll get replay information if you register for this webinar, so you can go through these. But I just want to show you, by showing you these slides, more that there is a process. There are just things to do, and they're not legal little goals. You know, you can really come up with something that works for each and every student that has different things. You know, disorganization, I mean, there's so many things that you can do for a disorganized child, but it's got to be, you know, if my daughter's paperless, that doesn't mean it's going to be good for every other child. That's why I'm saying I don't want you to look at this and say, oh my God, yes, I want this for my child. It may not be appropriate. Plus, the school district may not provide you with the same device. If I give my daughter a computer and say, that does everything and talks to her and has touchscreens, like, and the parents are like, well, I want that. That doesn't mean the school has to do that. You know, I happen to do that, let's just say, for my daughter. So going paperless may mean very different things. Again, social problems, you know, if that's part of the disability, social is part of school. So if the child, you know, can't work in groups, you know, that's a big deal. And we need to talk about that in terms of setting up accommodations. I just want to briefly also talk about testing accommodations. You know, those are some of the accommodations that you get. So, you know, extended time, again, these are some examples. These isn't, you know, a full list. Allowing rest time or frequent breaks, preferential seating, provision of scribe, permission to take exam on a computer. And I just need to hit this home. Testing accommodations on a 504 and IEP does not equal testing accommodations on the SAT or ACT, okay? If you have a 504 that says that you get extended time and in a separate location and your child does not use it for every test, in every class, the SAT may not grant it, okay? That's difficult in high school because a lot of times kids are embarrassed. So this is when we're really going to start talking about that self-advocacy, like understanding your disability. So you say to your child maybe, and again, I'm not telling anyone how to talk to their child, hey, I know it's embarrassing to go to that separate location, but you are not going to be able to learn one day in college if you don't. You're not going to do well in college. You're not going to do well on tests. You know you need this. You know you need that to be away from people. You know you need that extra time. You know, don't try to rush everything in. You know, if the teacher's not giving you the location, ask for it. Because what's going to happen is, you know, the SAT, where the child really does need this, they're just not taking, advantage of the fact that they have this. The teacher can't force you, drag you kicking and screaming into the extra room and tell you you've got to finish, oh, you can't finish on time, you have extra time, keep going. So you need to make sure, though, that you tell a student that, you may learn differently, and you need to kind of embrace that and understand that everyone learns differently, and this will help you in the future because you will run into problems on the ACT and SAT. Again, we're going to have an entire webinar later down the road on this, but I just want to talk a bit or just give you one bit of information on Diploma Safety Nets. If you are entitled to special safety nets if you have a 504 plan, just like you are if you have an IEP. And there's certain ones like a 55 passing on a Regents. And again, we're going to talk about that later. But on a 504, it's like automatic if you have an IEP. And a 504, it's got to be on the plan. Okay? It's got to be on the plan. If it's not on the plan, you're not. It's not an accommodation they feel that you need. Okay, so you can't come back after getting a 55 and say, hey, you forgot, give me that. Because you may not have needed that, and you just happen to fail the Regents. So just keep in mind that, there is this safety net, and if your child requires it, to remind people at your 504 meeting that it must be on the plan. We're talking 504, we're always talking general ed. Very rarely have I seen a child taken out of, unless their behavior is so bad that other students cannot learn in the classroom. Usually they're kept in the general ed. I mean, you're not moving them out ever. Sometimes you are being placed at home though, for certain reasons. But in terms of, you're not going, there's no special schools for 504 students like there are for special education students. You know, parents, this is all about parents, this monitoring. Again, we don't have this contract, okay? So how do you just assume the school's doing what they have to do? No. I don't ever think a school's out to get you, but you've got to monitor this. I'm a special education attorney. My school district knows that. They've completely not done something for my daughter, not on purpose, because they didn't know. So I have to ask her over and over again, did you, get your extra time on the test? Did the counselor come out and talk to you? Did you get big? And she says no, and then I make a phone call. Okay, this is not something, it's different. The IDEA and with the an IEP, if you don't get it, we can sue. If we don't get it, we can get services back. No, nothing like that with the 504. So, so there's a grievance procedure for a 504. The grievance procedure is it's still the same, like your procedural safeguards, but it may look different. Okay, some school districts, the law just says that the school has to give you an opportunity to dispute it. Some school districts make you go to a certain person, it's in the student manual, or you ask for 504 procedures, and it'll say you need to go to the assistant curriculum, the superintendent of curriculum, and start your appeal there before we're going to go to a due process, for instance. So it's not the same. You have to look at the school's, the school's procedure. That's a big difference between that and the IEP. So you're going to want to probably talk to a lawyer about that. Like I always say, when you're going outside of the school district to grieve. Also, we're talking Office of Civil Rights. It's a whole other animal here. So, this is a civil rights violation. Does it get to the level of a civil rights violation? I mean, that's, we can talk about that at another time. Non-academic, like for instance, if my child wants to be in the Science Olympiad, like they're really smart, maybe, and maybe they have Asperger's syndrome, and maybe because they have Asperger's syndrome, they have a 128 throughout the day. Does the school have to provide the aid at the after school? Maybe. Athletics, these are tough application areas. If you can make the team, do you still get certain accommodations? Summer programs, field trips. They can't say to you, you cannot come on our Washington, D.C. trip because you're hyper. You can get your accommodations, okay? Biggie, and I hear this all the time, which makes me so upset. You can't force a parent to attend. They said your kid can come, but you have to come. No, no, no. And you can't charge a higher cost either, okay? Tough application areas, are after school, we talked about that. Like what, the Science Olympiad, if a kid, I would say if a kid needs it in every single class and they're smart enough to be able to get to the Science Olympiad, probably they would need one. Again, no legal advice. You did not hear this from Cheryl and Erica at a webinar and you're going to tell your school that. I don't know. That's why the question mark is there. Everyone's different. And here, informal modifications already in place and working. Like, yeah, like we're doing that already, so what do you need? I don't know. AP classes and honors, like is it ever too onerous? Remember, we have to say that, there is that balance. That student that gets all A's and B's, with a student with diabetes, it may not matter, but if it's a learning issue, if a child's getting all C's, does that mean that's not their aptitude? I don't know. Again, that's why they're tough application. Just your regular education teachers have to do this. If they have a plan, they have to implement it. I can't tell you, even in my own life, when I get on the phone with the teacher, this is not a special ed class, Ms. Frischman. I know that, but that's the kind of attitude you're getting. It doesn't matter. So what I say to them is, if my daughter was in a wheelchair, would you take away the ramp to get into your classroom? Because it's not a special education class. Oh. So sometimes you just have to talk to them in a way so they understand this is access. My kid cannot learn unless you put her in the front of the class. Everything on that 504 she needs because she has to learn. This really comes into play when you're kind of switching classes in middle school and high school because you're one teacher doing it, another teacher not. You know, this teacher doesn't believe in it. I don't care. So again, academic intervention versus 504, they are not the same thing. Okay, you can have students in school that are at risk of failing the state tests, and the school is giving you something called AIS services. That's not special ed services, okay? Very important to understand that, okay? That doesn't mean you're a child with a disability. That doesn't mean you're protected. All it means is you're a struggling student, and they're giving you work. So sometimes a student with a 504 and IEP may have these services too, like building level services that they just have. And you're saying, but I want it in my 504 plan. It doesn't go in the 504 plan because it's building support. It's something they give to all students, okay? And I get this a lot where there's like, well, my child's in building support and, you know, that he didn't go 4 days or whatever, the teacher was absent. But you know what? That's not part of your 504 plan. That's an academic support. Like, we have to have a different conversation, okay? A temporary impairment, typically it's got to be more than 6 months to begin with, and it has to be severe, that it actually limits a major life activity. Okay, so it can't be minor, transitionary, which means you know, something that's going to go away, and it, you know, typically we say 6 months or less, unless it's really major. Like if a child had a brain injury, I had this happen, like, and it looks like she'll be fine in 6 months, but still needs that, would be okay, even if it was under 6 months. But if, like, the child broke their arm, like, the whole school doesn't have to, you know, come and do a 504 plan, okay? Episodic or remission, like Erica said, like you can have a kid with diabetes that is stable for a whole year. But then, you know, one day you can still have that 504 plan, okay? Tough application, we're not going to go into detail here, but, you know, anybody that gets federal assistance has to have 504. The way they apply it is different. So, you know, daycares may get federal assistance or grants, or a parochial school may get grants. You know, it's something. But it's minor adjustments, okay? It doesn't have to be full accommodations. They have to give you equal opportunity and minor adjustments. So a parochial school can very well say, and Erica has a child in a parochial school, can say, hey, no. And that is not considered discrimination. Very important. Now, we're almost done, but there is another slide here, and that it should be here, but the reason it's not is because we have a whole webinar on it, okay? College, all right? Huge. The application of 504. There are no IEPs in college, okay? Your child does not take his IEP in college. So 504 becomes very important in college. The reason I'm not talking about it is because there's a whole webinar on that, okay? So look at our schedule and please tune in if you're interested, because it is huge, college, okay, and 504. And we're actually going to be bringing in an expert to talk to you about 504 in college. Our next webinar, I do have one question, but our next, I just want to quickly say that our next webinar is on transition, which is, you know, one of my favorite topics in the world. It's getting the child ready from school to post-school activities and what that means. So please tune into that. Also, please know that there's a replay available for this. If you registered for this program, you'll get information on the replay. Also know that any of our previous webinars are on our website, www.specialneedsnewyork, and we talk about these things all over Westchester, all over New York City, all over the Hudson Valley. So we also have our events as well on our website. I have one question. In a situation where a student only requires a health para, may the district continue using an IEP although no other service or curricular mods are required, or must it be converted to a 504? There's no real must. You know, a school district can keep the IEP if the school district keeps the IEP. You know, I think that probably falls into a 504 arena, but if the school district is not saying anything, I mean, I wouldn't immediately, because remember, if you have the IEP, you're automatically covered under 504, so it doesn't really make a difference. So I would always, if you had the option, we would always choose IEP. But nobody, well, you know, if you had to choose as a lawyer, I'd say always choose IEP. So do they have to? No. You know, should they? Probably. Do you have to remind them about it? I don't know. Okay, so, you know, I'm not, you know, I just think about that because you're automatically covered. So Erica and I so thank you for joining us today, and I hope you got a lot of information out of this webinar, and I hope you join us for the rest of the webinars in our series. Thank you very much.
Thank you.